Where they low price, as you know, the final product is very expensive. So clearly, they have a very aggressive attitude with people trying to infringe or infringing patents. And then Samsung 2-3 years ago was a multi-millionaires, billionaires trial because there is a lot of money involved. Or the David and Goliath story, blockchain competitors. So this is a more aggressive way and financial role. I think this is something okay, you are learning here. Your card to play and to get money from the bank to discuss with partners at the company. So what is important is you have to build, you will build eventually a patent portfolio, and then you will modulate according to type of invention, market, etc. So I know as there, so you might have a few patents where really you want to insist 5 others, so you are very safe because there is a long procedure. We will see next week with the patent attorney. Writing a patent is not easy. Requires skills, cooperation between you and the patent attorney. So there is a patent procedure, as search examination you will see in a moment. So what is in? So that is quite safe and expensive to get to a patent. So you are not putting yourself in danger because you infringe. A patent doesn't infringe another patent. Okay, unless you believe because you have a patent you can do everything you want. Okay, you are going to defend and not just patent something because you have a nice idea and in practice the idea thing is not really applicable. Okay, so contrary to what I said in my slide at the beginning, I didn't mention I copy Dilbert. I should have put at the end of the so I should have. Okay, I can use this because this is a university training lecture, but finish the copyright of the Dilbert cartoons because I didn't mention this in my presentation at the end. Next time I will do. But this slide shows you what is happening in the who are the actors of the patent procedure. So today you are seeing the people sitting here, the patent office, or me. You have the people, these guys here, and the next week you will see the guy like this. Hopefully he has not the hair like that, but anyway. So basically the inventor and the applicant is the physical person who does the invention, and the applicant is the company to whom belong the inventor. You have the representative, the patent attorney, and then you have the patent office. There are conditions under which you can directly go to the patent office and avoiding the that I strongly advise to have a patent representative because I think this will help you to avoid surprises on the procedure. He knows the language, he knows what to do, and in writing the patents, very often the patent attorney are formulating the patent in a way you get the maximum possible protection. The patent office will do 2 actions. One is in a second phase, he will publish, the patent office will publish the granted patent. So rubber stamp, okay, finally got the patent. And then we call this a publication A, and these are publication B. Few now more technical stuff. So, as you can imagine, I already mentioned, patents are valid in a country, not in another. But what happens when I file a patent in a country and move to another one? In fact, this was a problem in 1883 when this convention has been established. And we didn't want to go to there was the empire at the time. We didn't want to go to Vienna and present the invention because they were afraid the French guys going there, seeing the invention, going back to France, and just doing what I said. So what was decided at that convention to get the inventors participating in the universal, what was called exhibition, was when you file a patent application in one country, you have 1 year to file a patent application in another country with the same content, and the date, the actual date you filed, filing date, will count as this one. So if somebody see my invention for whatever reason here, and 2 days after, and now with internet, the day after, or in 5 minutes after, files a patent application in another country, because of the Paris Convention, if I want to protect in the second country, and I file there at F1, F1 is in reality F0, so the people cannot copy. Okay, this is the example. So I file in Italy, start in Italy, and then I file in Europe, a European patent, and then in the US. But these 3 patent applications actually are as if they were filed. So nobody else can go there. Publication of documents prior art found which can kill my patent are not considered valid because this filing is put there, so this document is not going to kill my patent. But, and this is happening, after 12 months, my product is good to be filed in Japan, and because finally I can. Japan is very interested in China because China is a big population. Sorry, if you file there, you can claim F0, and any of these publications, D1, D2, D3, D4, will kill the novelty of this invention if this publication contains the same information here. Or even, as it happens, if my publication in the state A is published here, can be used against this one. So be careful in deciding the strategy. And what is this is another reason why you need a patent attorney. To be honest, even patent attorney, big company, they try this trick. They finally discover there is a new market that they forgotten, or an invention was at the beginning not really important, or they didn't understand the value of the invention at the beginning, so they try to file after the 12 months, claiming the priority, but then of course they lose the rights. So when to file a patent? Well, okay. You can read it yourself. What is important is file a patent before you disclose your invention. Because as I shown here, if you disclose your invention here and then you file a patent, this disclosure, P1, which is a document, which is an oral presentation in public, a conference, this disclosure will kill novelty, will be considered part of what is called prior art, or what is available to the public, and then okay, so be careful. So as long as your invention is secret, you may decide not to file a patent, but the moment your invention is presented to a conference or exhibition, be sure you have filed a patent application. Otherwise, and what we do at the patent office very often when we check, we look at who is the inventor of a patent, and we check in the patent literature database of the publication, etc. There is a publication of that inventor, and then we can use this to kill them. So, already said who was doing this. Where also this is, I said, patenting around the world is very expensive, so you should limit the country where you really are an interest in patenting. You can block, exclude others producing, using, and selling your invention or enforcing. So then you should, in doing that, you should be careful. Check the volume. Okay, first of all, where if an invention is produced in a single country, because there is a specific tool, there is a specific knowledge. For instance, now the all flat screen are produced in Korea. So the majority is produced in Korea. So if you want to block a patent on flat screen, so then file a patent in Korea. There's no point in patenting all around the world. If you want to block based on the volume, okay, you can patent in China, because the big market is there, and in Europe, patenting 4 or 5 countries. So when you're patenting in Italy, Germany, France, UK, so basically you have covered more than 50% of the population of Europe. So if somebody wants to copy your invention and go in small countries, maybe the producing in small countries where you don't have a patent is not economically viable. As you know, now the car producers, they are making joint venture conglomerate, etc., because they need to produce a big volume of cars. So, and finally, because you work in an area where there are standards, or I also learned here there are some people from biotech and not expert in biotechnology, but there are different regulations concerning biotechnology. There are different standards concerning technology, ITC. Don't patent where your invention is not applicable because of the standard. So, for instance, if you okay, well now it's compatible, but in the past, the mobile phone in the US, they have a completely different protocol system, so there was no point in publishing patenting GSM in the US. Probably it's not a good idea to patenting fridge in the Arctic countries, because probably they are not using, well, you're not going to fridge over there. There are procedures in national patent office, each national patent office, but there are possibilities to have a group in the countries and filing patents in more than one country at the same time. And this is what you can do with the Patent Cooperation Treaty or the European Patent Office. This brings you benefits in terms of similarity of rules. Going 38 states, 38 different procedures. You just go to the patent office, one single procedure, you talk with a single person or a single examining division, and speak only one language and not 38 languages. So This is why we suggest to, we suggest in certain cases is if you in 3 countries or so, the European Union patent, community patent also called, which will bring also a unified patent court for litigation, but is not yet in place. On the procedure, so there are a lot of steps. Priority filing is when you file national, so the F0 I mentioned, so you start national. Then you go to European filing, F1 for instance, in 12 months. We do some examination formal requirements. This is a typical patent life cycle. So we start, for instance, with a national application priority. This is the F0 I mentioned before. Then there's the European patent before 12 months. 18 months there is a publication. And then, 4 years depending, you might have the final patent granted. And the protection can last up to 20 years, and then the patent expires. The idea is, like also the other memory speed of computer every 18 months is double. So basically, what you invented here, and you file the application, you invent this problem here, file the application here, 18 months here, you have the therapeutical test of the are forbidding some kinds of clinical tests on animals or humans, etc. Takes years, and sometimes before what there is called the protection, I don't remember, which allows you to postpone the to extend the validity of the patent because you didn't have time to invent, to recover or to make more money, let's say. Okay. Again, this is an area critical person. Okay. These certain patents can go have this ramification. Where to file a patent is to show this slide showing patents granted per millions of people. And this is the number of people per country. So this is 10 years old. You can expect now, this was Japan, you see, US. Sorry, yeah, this is Japan. This is, okay, you will, Taiwan, this is Taiwan. Taiwan has a lot of patents, but then you can see now, okay, if you go to this website, they will distribute to you something. What do you have? Can you tell me what I gave to you?
Patent application.
I gave you the patent application.
Okay. Patent specification.
And the patent specification. So if you look on the bottom up right corner in the search report, and in this document, in the search report tells you what was published before the filing date of this application in the area of paperclip. You are seeing I gave you the invention because in the so. It's not an abstract paper, there is even the invention. And as some of you said, there is also 12 months minus 1 day was published, was filed in the European. After 18 months minus 1 day, something like that was published. And 1991, 2011, so the patent, this patent now has expired. So if you want to copy and start building yourself this paperclip, you these are the true legal part indicating what is protected by this invention. Is there in the clause of your contract? So there is a lot of, I wouldn't call blah blah, but paperclip. Interesting also, as I mentioned, they are using, you might use the patent, but be careful because they have registered trademark, paperclip, paperpin, and trademark, and also they have registered the IP domain. So this is a good example with a very simple invention, as you see here, paperclip. So first of all, this guy spent money to that application. So it's not just a desire, I want to go to the moon, this rocket brings you to the moon. So, but we need to have some disclosure of technical features telling you how you go there. Must be novel, the invention. So as I said, nobody else has already done in that form the invention, otherwise we cannot grant the patent. And is not an obvious invention, so it's not a minor modification in procedures. So, as I already said, new is something not available before your filing date, or get rusty or oxidation. Then there is the plastic, but you know plastic is polluting. So now our idea is to make, basically, we describe how this is built. So basically we have some main body, a lid, cover, and a spout, which is this tube, number 4, and a handle where you can grab the watering can, and then you can put water on your plant. And then, as you will learn next week, so the pattern attorney transform all this, I call blah blah, the explanation of why this invention is I did this invention, in this claim, a device for watering plants having a water-containing portion, this is the water-containing portion, a handle, an opening with a lid, okay, the lid there, in this, and then also have a little variation here where we, instead of handle, I use all the elements, okay. And then I do my own prior art search, and I discover all these elements. Now the question, the little exercise to you is, if as an examiner I will use this one of these ABCD to say claim 1 is not known because all features of this this one. You have okay, definitely this is really for watering plants, but you have a spout, you have so you have okay, of course you can use a Coca-Cola bottle to water plants. You have a body to contain water. You have well, then the question is this to the applicant. Of course, the applicant can come back and say, well, wait a minute. This is a tip-off, yes, I know, but then you said a device for watering plants, and the ones we excluded before. What we are going to do quickly on the skilled, the inventive step. Okay, I said is novel, an invention is novel. We have seen we should put ourselves in the shoes of the skilled person. The person is somebody who knows everything about the technical field, but is not able to make any intellectual combination link between different fields. Basically, a skilled person is a kind of database with all information, everything available in the world, but is not able to combine the information. So you need a CPU, a brain, to combine the CPU. So, already existing. To be more precise, if you find a solution in in the prior art and the solution is automatically so the things is obvious. I'll try to make this a little bit clearer. So what you have is you have your prior art, you have all documentation, you have a document telling you, okay, this is the closest prior art, your invention, something similar to your invention, your starting point. It exists also in the prior art another document about doing any mental activities, and to do that, what we require, this second document tells you have to combine this document per character or object could be made with aluminum, and because of lighter, corrosion resistance, etc. If you find these two documents, say, well, okay, car made with steel, iron, and you find the other document telling you, well, okay, you can make an object in aluminum and replace what is done in iron. So if it is in this document, then you say, well, the combination is quick description of what cannot be patented. There are discovery, gravity formula, gravity, so this is the idea, because this is something in nature, so exists in nature, but you can patent the application of gravity. You cannot patent aesthetic creation, and what is important, you cannot patent computer programs is here. And going back to computer program, or to forward to computer programs. Computer programs per se are not patentable in Europe unless they are in combination with simple. I have a more difficult one. So if you have a program for controlling an X-ray apparatus having instruction adapt to carry out the following steps, so taking moving the body or scanning the body, acquiring the data, filtering, amplifying, and creating an image, you have in fact some technical effect because you have a process producing something tangible. What you have here is a program for checking the spelling of word processor, basically checking against a dictionary, telling you whether you made a spelling mistake or not. So it's just something you have in your mind. Text is data in a way. So okay, so the problem is there is no specific definition of what is technically the European Patent Convention. So our partners, control values of a process. This is just a business or financial process or mental act as correcting a text doesn't fall in these two things. And I make here, okay, so basically what we are doing is, this is the claim, and the subject matter of describing non-technical feature, not technical character is not patented. Sometimes there is a mixture, and then you have to check if, and you exclude this one unless they give certain flavor to the technical character. I make a very simple example here in the simplified example in the magazines. They give for free access to scientists working in countries with low gross domestic. So, send a request, understanding, determining in whichever way geographic location. So, okay, well, you are from a low GDP country, so So we are in this situation. We have a little bit technical, a little bit still the old non. Okay, so then we have to check whether having a computer, etc., is invented or not. You will see the presentation. And then, well, the presentation will say, well, not too much because you just use ordinary network computers. So what the guy has done here, finally, he has said how he's going to determine the geographical location of the user. So which country the guy is coming from, his own methodology X, Y, Z. And so now we are in a situation where we have much more features. And if these additional features are something new, and if the priority is here, you have these technical features are novel and maybe innovative. You will, okay, method of treatment are, despite their invention, are excluded because, can you imagine, I get now a heart attack because after 2 hours speaking, I'm dead. There is a method, the method of treatment are not, but the tools, the stuff, yes. Okay, now the last 6 minutes. This answer will answer some question I get always here. So what is infringement and freedom to operate? Infringement is if your invention, your product is falling inside the scope, the claims. So novelty we already described before. So now we are going to check infringement, play novelty infringement. And well, this is very important. If your entity or activity, method or tools is not infringing an existing patent, you have what is called the freedom to operate. Okay? And if the entity and the activity, your one, is also novel, you may seek for patent protection. Claims, mobile phone handset comprising a casing and an extensible antenna, characterizing that the extensible antenna is telescopic. This is a similar claim as you have seen for the watering can, so very nice letters. So we then play only with letters because it's easier in our building tables, etc. So we are going to do this in practice. So we are now checking novelty of a claim 1, 2, 3, 4, 5 as we did with the watering can. And we have a prior art object, document, whatever, you know it's public, and we have ABC. Now the question to you is claim 1, 2, 3, 4, and 5 are novel or not with ABC. So you are now designing. So is claim 1 novel? No. Claim 2? No. Do you agree? Because all features are. Oops. Claim 3 and 3 is novel. Okay, of course. ABC first. Somebody says yes, somebody shakes hands, head, right? Good, you say yes, good shaking heads. You will see later why. Claim 5, novel, okay? So basically, if you have a car with, let's say, 3 wheels, first you invent a tricycle, and then you invent the bicycle. The invention of the bicycle is not novel. Think about it. You're right, it's not novel. Or you have a table with 4 legs, you invent a table with 3 legs. The invention is not new. Don't look at me like this, because the claim is written that way. You will see later why. Infringement. Now we have a valid patent claim ABC. You have product 1, 2, 3. You want to put this on the market, and then, but you know there is a valid claim. Then you have to assess whether you are infringing. So, and infringement is, I said, all features in your product can be seen in the valid patent claim. So is the product 1 infringing? Yeah. Product 2? No. So if you, okay, so you have a pattern with the 3 wheels tricycle, you invented the bicycle is not invented, but you don't infringe. Okay, so weird. That case, A, B, C, D. So you have added a feature, is infringing or not? Infringes because even though you have something, the ABC is there. ABC1 or first. We don't know, so it depends. Literally, what is called the literally, I'm cutting the words because there's one leaf left. Literally, infringement is when exactly the feature is present in your object and the plane. There, C1 maybe is just an equivalent, and then according to the court, according to the doctrine, maybe it's infringing yes or no. We don't know. And this one is not infringing because obviously you don't have it. So now we go last bit. Pattern invention featuring existing featuring ABC existing force. You want to put it on the market a similar product, and also you would like to know whether you are infringing, and at the same time you want to file a patent. So the situation is complicated because you have the valid patent, you have the product, the corresponding claim, and then you are, before going to the market, before deciding your strategy, you are doing all this exercise, and then here I am going to indicate to you whether is novel, is patentable, or in this case, no freedom to operate. You cannot patent the invention. You have freedom to operate, but you cannot patent it. Here you don't have freedom to operate, but you can patent it. So if you remember, because you depend from this patent, you can have your own patent because you added a feature you have invented. But the usage is limited by this patent because you are using also the feature of this patent. This is what I said at the very beginning, relative right. And the only two you can successfully pursue are these two. So the C1 and D. Okay. So it's T time, but then we go for a hamburger case. So those are real patents. Those are real patents. Okay, so it is a real application. So we go. Okay, the first question is infringing. Hamburger number 1 is infringing. No. Hamburger number 1 first, where I replace the cheese with cheese flour dressing. Maybe. Okay, but yours is different. Okay, maybe it's equivalent. We will say no because we are Italian. I'm Italian, so but you know the cheese paste is used everywhere, even the pizza in Holland. So and it's not exactly like the mozzarella. So it is debatable. But of course, even there, if I add the tomato slice, is infringing because I'm using exactly the same cheese. So then, if we move to novelty, is the same. So, okay, this is novel. This is novel anyway because I added tomato slice, and here is novel because of course the same like here. So then here's the conclusion. So you might have well, then you have to decide whether you can really put or not, and then you do this. There are two more exercise in these slides, more technical and based on real cases. Since it's 5 past 5, I'm not going to present this. I leave you to read to have more stuff in the remaining slides. I don't know whether we can have still some question now. If you, okay, well, let's say you can stay until 5:15 without problem with the traffic, or I don't know the traffic is here in Pisa. If you have a question, so try to shoot some question. Otherwise, my email is in the slides, so you can ask me more questions. Yeah.
Sorry, but I don't agree because the payment system is not efficient enough in Italy. And so how do you think you could improve it?
Well, why is not efficient?
People don't respect property.
Okay.
Especially big company.
Okay, you're right. Well, okay. Well, I cannot say. I'm not accusing anybody. Not. But we are talking about the enforcement of patent and not the procedure. Yes, I would say the procedure per se sometimes is not efficient because I just explained before we publish 18 months, technology maybe is already obsolete, and maybe you have to go back. Small companies, a big company can maybe in 5 years' time, 10 years' time still be alive and fighting back infringers, etc. Small company, no. But unfortunately, yes. I'm not going to talk about the culture in Italy because well, it's just a nuance. You have this also in other countries. But definitely the this politics. Definitely the judicial system in Italy is slow, and of course doesn't allow you to get the real protection. So this is also why maybe investment in Italy invest, etc. But this is more about the code. I mentioned briefly the European Court of Justice for patent. Probably this will be a way is a remedy to this, because and on the other end is also the reason why a lot of, and Italy, by the way, didn't accept to apply to the European the unitary patent, because one of the obstacles is the nations, they have to give up the right to defend or to treat in court the litigation, the national cases. This will be treated centrally. Of course, again, if we do this in Italy and hopefully the European Court of Justice is more efficient, maybe this solves the problem, but obviously the Italian industry or the national industry is the real problem. And also the lobby of the national courts, they don't want to give away this right, because it will be less procedures, less expert nominated, less money, etc., etc., etc. So there are lobbies not helping to make the system more efficient. But as briefly explained, the unitary patent, the unitary court of justice is going exactly in that direction. Plus, of course, each nation should do its own homework in order to improve that. More questions? Yeah?
What's the difference in terms of cost among filling eco patent, PCT, and national?
Well, okay, the PCT is just PCT at the very beginning is more expensive, but covers only the initial part, the filing. So basically, only the part going to leading to the search report. But you have a search report and also a preliminary opinion which is valid in 140 countries. So if you have really a good positive opinion and really you are interested in going to all these countries, yes, is cost effective to go to the PCT. Otherwise, it becomes very expensive. European patent anyway is limited only to Europe, so per se it's less expensive, but of course allows you only to protect Europe. With PCT you can start to have a preliminary opinion valid in Korea, in Japan, in China, US, and Europe. So with a single initial procedure you can cover basically plenty of countries, and you have 30 months before deciding to go national, so you save also time. Well, okay, it depends because European patent can cost 20,000–30,000 euro. The initial part of PCT cost an additional 5,000 euro. But then, of course, after the PCT, if you go to the US, you have to pay the fees in the US. So it's really difficult. Maybe the patent attorney next week is going to tell you more detail on the different costs. But also, the patent procedure I explained, the Paris Convention was designed to avoid people looking at your invention, seeing your invention going to another country. Today, with the Paris Convention, you first file a patent in Italy, then you have a 12 months time to decide what to do next. So then you buy time, basically. So the idea is to buy time, and to buy time, so you decide whether your invention is really worth going to another country, or you decide, well, okay, I did the initial bit of the procedure. It's better to drop this invention because it doesn't cover. Well, first of all, the idea is not very good, and then in the end, I decided not to go in that direction. Didn't find an investor, and blah, blah, and so again, a patent attorney can, well, don't start saying, this is a great idea. I cover the universe with patent because everybody is going to use my invention. And then suddenly the price of this goes down, and people see a new invention and stop using certain tools, etc. So so buy time, use the different tools, and then don't invest too much. But have in mind, learn. Patent is anyway something that you have in mind, and then you decide what to do. More question? Yeah.
I have a question. In one of your slides, you mentioned that plant varieties cannot be patented. As an example.
Yeah, I know.
But there are many agricultural companies that claim by producing a new seed variety that they need a patent or they want a patent.
Yeah.
What is the position of the European office?
Well, okay. As I said, biotech, all this stuff is not my field. I understand there are EU directives in this area, and basically we follow that. I know there are the famous Monsanto patent, all this stuff, so I cannot seed next year and have to buy new seeds, otherwise Monsanto can come to your place and kill you. But honestly, the details, if you want, I can send an email and ask your colleagues working in the area, and I'm sure I found the things. Honestly, that is definitely not sure. I don't want to say anything incorrect more than what I already said. Where I think I said correct. Okay, so I didn't give too much space to you, but okay, as I said, if your question, don't be shy. As I said, a lot of things are coming from the past, from your questions, even question I got by email. Just wanted to show the This will be also in the is about it's not about the song of Sting. It's about Coca-Cola. I use article written by somebody from Coca-Cola, and in fact, what you see incidentally, they started with the first design patent in 1915, and they keep renewing. Basically, they are covering design patent. Sorry, design patent, and so they went on with the design patents at the moment. They stopped in the 60s, and then they used the trademarks on time. What is also interesting is the licensing patent strategy they use. They switch from being aggressive to be more cooperative, try to sell things and changing focus. I think is that even though it's Coca-Cola, big company, still is an interesting example idea, and all this will be in the website. Thank you very much for your attention, and enjoy the rest of the PhD class.